Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday, 8 p.m. Eastern, a regularly scheduled live stream. I hope everybody's doing well. When you come in, just check out the video, check out the audio. Let me know if everything is working well. We obviously had a problem last week. 40 minutes into it, everything was shut down. No idea to now what exactly happened. Some people suggested it was an outage by the ISP. I have no idea. I have a dedicated line just for live streaming. Normally this doesn't happen, so I have no clue, but let's hope that today everything is going to work well. Obviously today we're going to talk largely about, in terms of what I'm going to speak about, is going to be about the MAGA lawsuit, the lawsuit by the Covington High School student against the Washington Post for defamation. I'm going to start the stream by giving maybe a 10-minute explanation of where I think things actually stand. Afterwards, I'm going to be open up to any question, obviously. So you can ask questions about anything, about this particular case, about the case that we are working on, about the case for illegal collusion and monopoly by Patreon, PayPal, and Stripe, one that I'm working with about 80 volunteers on. You're welcome to ask that, or really anything else that's on your mind or in the media, you're welcome to ask. So this is a live stream, so I need your question. So if you have a question, anything you want to say, you go into the comments, put an @youtuberlaw. You can see it down in the orange little bar beneath me. That basically tells me that you want me to read your question, because on my end, what I'm going to see is an orange box. So every time you put an @youtuberlaw, I see it and I read it. If you don't put that box like it says here, I'm assuming you're just talking to other people on the stream, so I'm not going to read it. So come in at any time, put it in. What's going to happen is that I'm going to start at the top and I'm going to go one by one, and I'm going to try to answer every single question, every single comment that you have. If there's anything to respond, sometimes a comment is just a statement, I have nothing to respond to. But if it's a question, I will respond to it. But, you know, it can drag out sometimes. So if you ever want to skip the line, use super chat. At that point, I'm just jumping. I'll cut the line and read your comment or your question right away. Obviously, you're not required to, but you are required to put an @youtuberlaw if you want me to read your question. Let me just take a look here and make sure that everything is working well here. Cons class Sith. Hello all. Broadcast 5-5. Outstanding. Rider in the skies, welcome back. Thank you so much. I'm going to start the stream now. I think we are a couple of minutes into it, probably a little earlier than normal, but I'm going to start the stream right now. We'll come back and I'll start talking about the case that is in front of us. Excellent. So today we're going to talk about the MAGA lawsuit, the lawsuit by the Covington High School student against the Washington Post claiming defamation. Now, we knew a lawsuit was coming. There was no way that this entire scenario, the way it played out online, there won't be some legal claim here. We didn't know exactly how they're going to frame it and how they're going to choose which media company. They chose the Washington Post. I don't have any knowledge into why the Washington Post versus anybody else. There are lots of players, and I would say that there's lots of claim for negligence or at least unethical behavior on part of a lot of different journalists, a lot of different reporters, and sometimes people online and YouTubers that jumped in there before really knowing all the facts here. I'm going to assume everybody knows what we're talking about, but on January 18th, I believe, near the Lincoln Memorial, there was a group of students that at some point confronted the Native American protesters, while there was also a third group at the same time protesting other thing called the Black Hebrew Israelites. Those three groups together resulted in interaction, for which we saw a clip. I believe most people saw the clip on January 19th, basically showing a very close confrontation, or at least a standoff, between the Native American protester, who was an elderly man, and a young student from a high school called Covington, I believe, Catholic High School. when we first saw the clip, we didn't really know any of the context. Everybody jumped into conclusion saying that it was, in fact, the students that somehow surrounded the elderly protester and actually jeered him and actually made fun of what he was doing, trying to be provocative. They were wearing MAGA hats. That's why it's called the MAGA lawsuit. And for a lot of people, that was enough. There was basically conviction in the court of social media saying that this is the problem with the world. This is a white versus minority issue. This is disrespect by the young against the elderly. Disrespect maybe by people associated with the Trump support groups and the administration and anybody that supports them against people that are otherwise opposed to it. A lot of different stories came up during that time, but it didn't take long for people to realize what we saw was just a tiny little clip that didn't tell really the whole story. And within a day, it became clear that it wasn't the students who surrounded the elderly protester, but rather that it was the protester who walked directly into the group and got into the face of the young student and started chanting. The young student did nothing. Nobody jeered. Nobody was no real disrespect. But it's all about perspective. And if there was any sort of jeering, if there was any sort of foul language, if there was any sort of disrespect, that came from a third group that are the Black Hebrew Israelites, who had a lot to say about everybody in the country, and frankly, they're not worth our time here to even discuss or mention beyond this little 5 seconds. But because of the enormous publicity that this event, especially with this little tiny clip, had over the internet, the student, not only the one that was identified eventually, but also fellow students and the school, received death threats and other typical kind of social media calls for violence or for protest, and people telling them exactly what they're going to do and what they think of them. There was a lot of negative social media attack against the individual students and their school. And this is where we're headed right now, which is a lawsuit filed by the student that was at the heart of that one clip, the student that stood face to face with the protester, represented basically in a lawsuit brought by his parents against the Washington Post for their coverage. Now, this lawsuit is interesting on many fronts, because this is a lawsuit for defamation. And we spoke about it many times, that a lawsuit for defamation in the United States is just not easy, right? It's a difficult thing to sue because we have such immense respect for freedom of speech. It takes a lot for the government to come in and say that you are not permitted to say what you did. And there are obviously very few exceptions to that. Defamation is one such exception that says that if you say false statements of fact that injure somebody, that will be the basis for defamation. So there was a lot of false statements of fact being made by a lot of different people during those 2, 3, 4 days. The question is, can we find it in this lawsuit specifically and against the Washington Post? And to be blank, it's not that simple here. At least the way the lawsuit is structured, the lawsuit is drafted. I'm not criticizing the attorneys for doing so. It is not an easy task to have developed that lawsuit. I'm just saying that if you start reading through the lawsuit, some of the required elements are not that clear. Let me show you something here. Let me pull up the lawsuit for a second here. And here in front of us is the lawsuit filed in the Eastern District of Kentucky, Nicholas Sandmann, that's the student, versus the Washington Post here. Now, the way it's structured, and I'm going to skip much of it here because there's a lot of coverage of a lot of different situations here. It basically focuses on various articles published by the Washington Post, and when they go into those articles, Section 118 here is a typical way it was handled. Basically, it says in the first article, the Post published or republished the following false and defamatory statements. The headline, it was getting ugly. Native American drummer speaks on the MAGA hat wearing teens who surround him. Now, the problem with saying that that's false and defamatory is that It's not stating any false statements of fact. It represents that the elderly protester had an opinion about what's happening here. So here the Washington Post is making reference to what was being said by another individual. So what they did was not false. He may have lied, but what they did was not false, unless you can show evidence that they knew what he was saying is false, and yet they still repeated it. And when you go through the lawsuit, that's pretty much what you see throughout the entire time. Here will say, in an interview Saturday, Phillips said, so that's something he said himself again. Or in D here, a few people in the March for Life crowd began to chant, "Build that wall, build that wall," he said. Again, a lot of the lawsuit is about, take a look at those articles, take a look at those provisions, they're false. But what's being pointed to are allegations of false statements being made by people that are being interviewed. Sometimes it's Mr. Phillips, who is the elderly protester, the Native American. Sometimes it's other individuals who are repeating alleged facts, but the Washington Post never actually states, I mean, not never, in many of those, it does not state facts that are false, but rather is repeating statements that might be false that are being uttered by others. And so I want to just explain a little bit here what's going on. Think about it this way. If somebody wanted to do an article about me, right, and why, and his title, maybe that's what they want to say, is "Everybody Hates Lior," and they know that there's 100 people out there, 90 people that are perfectly fine with me and 10 people that don't like me. Now, instead of doing an article saying, you know, it's a 9-to-1 hate to love, love to hate article, they decide to focus on the 10 people that hate, and they interview them. They don't mention about the other 90 people. They just talk about the 10 people and their opinion. Everything that they're reporting is true. These are all individuals who have an opinion, a negative opinion about me. Nonetheless, when you read that article, that will be misleading because it simply discusses basically a population that's 1/10 of what is actually being represented. That's kind of what we get here. Now, what we see is, you know, a focus on allegations made with total disregard for maybe conflicting information or information that will be in complete opposition to them. So what they're doing is not false, but the impression they create by writing those kind of articles is at the very least misleading, potentially completely false. So one of the issues I have here is that when that's the tactic, that's what you're trying to show, this lawsuit could have been better organized to actually highlight what the law actually requires, which is this. You know, what is the standard here? What kind of standard are we looking for? Is the Washington Post, in their reporting of what's happening, and we're going to take a look at the articles in a second, are they held to some sort of a negligence standard? Or do we need to show that it was purposeful, it was malicious? They knew exactly what was going on. They knew that this was false. Was it malicious? I mean, was it negligence? Or was it intentional? And then the idea is that you've got to create basically a timeline. Rather than doing an analysis based on each article and trying to show what each article might have been potentially defamatory or false, rather than actually focus on a timeline. The problem here is that this was a very fast-moving story, right? I believe the interaction happened on the 18th. The story really exploded on, which is a Friday, I believe. The story exploded on the 19th, which is a Saturday. Conflict information started on Sunday with information that this was really false, the original story. But by Monday, it was already clear where right and wrong was here, what was actually the factor. So it was very, very fast moving. And if the argument ultimately is that the Washington Post had access to information, either intentionally ignored it or negligently because that it was just bad reporting, or they willfully ignored it, they knew something was going on, maybe a reckless standard, then the goal should have been to set a timeline of events to clearly show when different information was made available online, so you can say, you know what, in the first day there was only the clip, in the second day there was already availability of the entire video, so things became clear. But the third day everybody knew and everybody acknowledged, and then we can relate that to specific statements made in the articles and show that even after it was already clear that this was a false story, the Washington Post ran with it. And that's not clear from the lawsuit, from the complaint as drafted, because they chose to organize it not around a timeline, but rather around statements in the article itself. And it's just never clear whether or not this was just bad reporting, or because the story was moving so fast they couldn't catch up with the information, and by the time they did, they fixed it. At least when you read the complaint alone, I'm not telling you that it's unclear to me. I think that at best it was shoddy reporting. I think that it was negligent. I think there was a lot of misstatement. I think that even when they knew the facts, they never really took back false statements being made. I'm going to show you what's going on here. So I absolutely think that the Washington Post was wrong here. I'm not happy with the way the complaint was drafted, because it doesn't clearly show the judge what are the legal principles that they're trying to explain. So let me just go through some of the articles here quickly to show you what's going on here. And the first one is this. Where is it? Oh, software froze. Shit. Sorry. Okay, gotta wait while... Here it is. Here we are. Okay, so here it was, and like I said, the headline itself doesn't really tell us much. Then it says something like the images in a series of videos that went viral on social media showed a tense scene near the Lincoln Memorial. This was an article written by Antonio Olivio on January 19th at 4:22 p.m. That's the first article that they mention here. Now, if you go to the second article here, Exhibit E, you see that basically this is another variation on the same exact article. So here, the lawsuit actually repeats two variations on almost identical articles written and posted almost identical times here. Where is D here? Sorry. No. So basically, the first article, which is Article 1, was written on January 19th, and then it was repeated a day later with basically no real changes again by the same individual, just reposted again the next day. But nothing in that article alleges fact. It's a repetition of what other people said. I'm not saying they're out of the woods because of it. I'm just saying that it's not as clear as saying that they actually said something here. Let's go into the third article here. And now we have here, marchers accosted by boys in MAGA caps draw ire. So this is an article by the same individual written on the next day, on the 20th. Bad English, marchers accosted. That should not have been an apostrophe here to begin with. Should be accosted by boys, just bad English, which doesn't say much for the writer here. But then again, the images and the videos that went viral on social media, well, that is not a true statement. Surrounding him are a throng of young, mostly white teenage boys, several wearing Make America Great Again caps, who stood 1 foot from the drummers. Once again, if you look at that video objectively without saying anything, then what they're saying is correct. It leads to wrong impressions, because when you're saying surrounding, it makes it seem as if they were an aggressor. But it's not an incorrect word to say, even if they were not the accosted, they were surrounding, because he walked right into their midst. So it's difficult to point at that point in those articles to anything specific. And what you see basically as you go through the article is that in the first couple of days, the Washington Post is basically just reporting what other people are saying, whether or not they had access to additional information here. G. This is an article on the 20th by somebody else, Michelle Bornstein, opposed to the dignity of the human person. That was a Kentucky Catholic Diocese condemns teen who taunt vet at March of Life. Again, it's about a viral video that went live. Again, not much of a repetition. You have to understand that in the beginning, on the 19th, huge portion only saw the little clip. On the 20th, it started surfacing additional video showing a different perspective, the full video. In effect, actually, there was a video on the 19th on the same day, but that was uploaded by the other protester group, and which a lot of people did not take seriously. But they actually posted a video right away showing the entire interaction, and that could have been used as in proof that really the original clip was misleading people. But nonetheless, the next day, an alternative video showed up that showed the entire interaction. So the question then become, well, if the Washington Post maybe didn't know on the 19th, but now people are learning on the 20th, at what point do they have enough information to know that they need to, even if they're reporting what people are saying, there should be an asterisk, there should be an explanation, there should be, but we have a video that contradicts it. And that's what seems to be missing from a lot of this, and that's the problem with the way this article is structured here. For instance, this is another article that came out. When did this one come out? I think it came out on the 20th. Most young men are much more open to diversity, and it doesn't say much here. Once again, but what's happening here, once you get into the next one and the one after here, this is already on the 21st. And now by the 21st, everybody was already figuring out that the original video was false. Okay? So now you have fuller view emerges of conflict on mall. Okay, so this is on the 21st here. But if you look at the actual, even though the headline could have given you a view of some information, they don't state what that other information is until very much late in the article. Basically showing here, the Israelites and the students exchange taunts video show. The Native American and the Hebrew Israelites say some students shouted. They say, build the wall, although the chant is not heard on a widely circulated video. So why would you say it exactly that way? Why would you say they saying that they shouted the wall, although it's not actually heard on a circulated video? Okay, still not clear what is what they call it, fuller views emerge here. When the Native American elder intervened here, which is, okay, now they're making an assertion that there was some sort of a conflict between the students and the black Israelites. So he found himself face to face with that dark-haired teen. Again, they're not saying that the teenagers actually accosted or surrounded him now, but they're saying that he found himself face to face. That is arguably misleading at its best. You know, is it a lie that he found himself versus he did it himself? Interesting. The young man at the center of the video, who identified himself to the Inquirer as the 11th grade Nick Sandmann, said that he and his classmates were called racist bigots worse. But what's interesting here, nothing happens until much, much later on, which is right here. It says, most of the student moved out of his way, the video shows, but Sandmann stayed still. Asked why he felt the need to walk into the group of students. First time they're acknowledging that they saw on video that he walked into them. Philip said he was trying to reach the top of the memorial where friends were standing. Hold on a second. So your title said there's a fuller views. You're repeating the same kind of, not direct lie, but rather the assertion that he found himself, right? Where is that exactly here? That he found himself here. A Native American elder intervened, singing and playing a prayer song. He found himself face to face with a dark-haired teen. But not until the very end is there an acknowledgement that that's not what the video showed. So you have article after article that is just focusing on one point of view based on the original little clip. Arguably, during that time, during the first 2 days, the fuller video comes out. They're not acknowledging it, really. And then when everybody comes out and says, okay, this is really not what happened, they come back, never retract what they say, never put, you know what? Maybe those viewpoints were wrong, but rather now start publishing. And it's if you see the next article, it's the same exact storyline where they are repeating the story that's been told over the last 2-3 days. And at the very end, again mentioned that the actual video may not have shown those facts, that he actually walked into the group. They never accosted him. They never actually surrounded him. So now you have a situation that I'm saying that's where my problem with the complaint is, that it's not well organized. Rather than organizing it by articles and pointing to different statements and largely using the word the gist. It's always about the gist of it. The idea being that by making all this statement, they make the impression that the kids were actually accosting the elderly protester. Well, that's not untrue, but the courts are going to look for statements of fact, not the gist, not impression, but rather statements of fact. And it would have been a lot more helpful if they organized it around a timeline showing when the story came out, what kind of videos was made available, how many media outlets knew already that there was a fuller videos, and when did the Washington Post start to actually mention that there was really a true storyline, and how they really didn't change it, didn't retract what they said, they never corrected it, but rather put that kind of a statement at the end of an article, not in the beginning where they were repeating that same kind of false storyline that's been circulating at that point for 2-3 days and was already proven to be false. So I think that there is enough evidence, if organized better, that the Post was negligent here, at the very least. Potentially that they knew exactly what was happening. This was actually malicious. This actually was intentional. But definitely when you can, I think you can definitely reach a point that you can show that by the time, if this was on the 19th, by the time the 21st came along and you're still repeating the same story that you know was actually false for the last 2 days, and you actually don't correct it, but put a line at the very end that actually contradicts what was being said in the very beginning, that you are pushing for the false statement even though you know that it's not. So either negligence in the way it's right up, or potentially purposeful statements of fact that you can see how that was injuring somebody. The point then becomes, well, what is the standard? Can you sue them based on negligence? Can you sue them based, or do you have to reach the point where you have to actually prove that they knew everything? And in this case, my belief is negligence will suffice. When a lot of time when public figures are suing the newspapers, when Sarah Palin sued the New York Times for making defamatory statements, the court came back, says yes, what the Times did was negligent, but you didn't prove that this was actually purposeful. They actually knew that everything was a lie. A public figure, you have to prove purposefulness. The idea is that you put yourself out there in the public. The standard for defamation is much higher than a normal person. There is this concept in law called an involuntary public person. Basically, the idea that sometimes people are either purposefully, they put themselves in the middle of a story, or they're pushed involuntarily into a story, and as such, the standard applied to them would be higher than a regular person. I don't think that would apply here, because this is a private individual. All the students were private individual. They never thrust themselves into the storyline, and it was the very organization that then accused of defaming them that then actually pulled them into the public eye. So I don't believe that the Washington Post can say, well, that he's a public figure. As a result, the standard has to be, you have to prove that we actually knew and this was purposeful, because they're the one who pulled him into the limelight. They created they repeated that false narrative. They doubled down, tripled down. They wrote in a span of 2-3 days, 7 or 8 different articles repeating the same lie and never actually retracting it. So they can't pull a private person into the public arena and then use that as the basis for actually saying that the standard for defamation is higher. So I believe defamation, I believe that negligence should be suffice. I'm not convinced that the way this complaint was structured at this initial stage gets you there, because I really think it needs to be reorganized. Personally, I would suggest that they do an amended complaint, but basically reorganize around a timeline that actually shows when everybody knew the facts and how common that information was within the media, whether or not, you know, what was known on the 18th, what was known on the 19th, how many media company already picked up by the 20th that there was conflicting information, and did the Washington Post keep repeating the false narrative that other people were spinning without providing any sort of asterisks or disclaimers well after it was public knowledge that the story was false. Anyway, that's my opinion. I think it's a very, very early stage of this lawsuit. I'm happy that it's going forward. I have a problem with the way it's organized, but I'm very happy that it's going forward. I suspect that they will do well. I mean, I'm sure that the attorneys will go back and there'll be a number of amendments. There'll be motions to dismiss, and there'll be a number of amendments provided by the attorney. So this is just the beginning, not the end. Let's take a look. Let's go back now into the stream and see what kind of questions you got have. Remember, guys, and you want me to repeat your comment, you want me to respond to your answer, put an @youtuberlaw in front of your comment. I'll read it. I'm going to go one after time. You want me to jump, you want me to skip, you want me to read your answer without don't have time to wait, just super chat is the way to get the fast pass. Consclanseth, let's all hit that like button. Guys, please hit the like button. That helps a great deal. Aflac Awake, do you think that they have a good case that the Supreme Court will eventually get in their courtroom? Oh, wow, that's really, really early on for the Supreme Court. The court, I mean, you can't get there unless there are mistakes that people are appealing it, you know. This is a case that I believe, regardless of where it ends up in the district court, it will be appealed to the circuit court. I don't think this is a case we'll go to Supreme Court, because we have pretty good definitions of what is a lot of precedent into defamation and freedom of speech, the standards. The question is whether or not they're going to be applied correctly. That's why often they get appealed. Whoever loses appeals it. Not sure right now if there's enough of a question that would be contradictory in one circuit versus another that will rise up to the level of the Supreme Court here. That's when you get to the Supreme Court, you know, when a decision in one circuit actually contradicts another. And so I can't imagine that's happening. This is not a question of law that is uncertain here. We've dealt with this many, many times before. So I think that they have a good case. I wonder, and maybe one of you can tell me, why they chose the Washington Post versus anybody else here. Maybe they just saw more instances. Maybe the Washington Post just inserted itself into the story more than anybody else here. But I think that there's a case here if they organize it properly, if they lead the judge through the issue here, they actually explain it, why they think that there is proof of negligence, because they've shown a timeline how information spread across the internet. I think that they have a decent case. Sidoku, do you believe censorship accomplishes its intention or vice versa? Oh my god. I think censorship never accomplishes anything. I think that you don't have to look at the United States. Obviously, you can look what happened around the world. The stories always get out one way or another, and it's far, far worse when it eventually gets out, because it tends to be distorted over time. So I don't think censorship helps in any way. Definitely not when it's done by the government. That never works. And now what we see is private companies practicing censorship. It doesn't accomplish it. It works in one sense, that it does, in the immediate sense, suppresses speech. In the immediate sense, it suppresses competition when censorship is not only done on an individual basis, but also on a platform basis. It can kill off competition. But over the long term, that does not work. But we live in a short-term kind of world, and so we face the benefit, the risks, and the harm from censorship. We can't all wait what's going to happen over the next 20 years. That's why we started the complaint against Patreon, PayPal, and Stripe, because we believe that the harm in the short term is far more important than any sort of fix that will be implemented over a long term. Asfera. There was someone there live streaming the whole thing. The truth was known and the news still ran with their narrative. I mean, I don't know about the live streaming. I'm going to go with what the complaint says, right? So the complaint mentioned the fact that on the same day, a full version was uploaded by the Black Israelites showing what happened, and that would have been sufficient. Now, how many people followed them? How many people saw that? How many people gave credence to what they were doing? So it's not clear to me whether or not that video that was uploaded simultaneously with the small clip can be said to have put everybody on notice, or was it more of another video posted by somebody else that did so a day later. But I agree with you that at the very least it shows that there was tremendous amount of negligence by the Washington Post. I've talked about before. I think that at the heart of this issue is the fact that newspapers are, and basically all media companies are, losing so much business because they're competing with social media. They're competing with the person on Twitter, the guy on YouTube, the guy on Facebook that are posting their own stories. And as a result, they're rushing to push out a story without actually verifying it. So instead of saying, you know what, there's a lot of garbage out there, we, the media, we're going to focus on actually getting the details straight. We're going to interview both sides, and until we know otherwise, are going to give the benefit of the doubt to both sides. A lot of these media companies, the Washington Post in here, and you can see that through at the very least 5 out of their 7 articles, and I would argue in all 7 of the articles that's being shown here, they're just pushing forward whatever information is being fed by individual. They are not really doing their own analysis. They're not trying to come up with an even-handed approach. They're just feeding into the social media frenzy. If they're not creating it themselves, they're just feeding into it, because I think they're competing with social media here. So I think for me, it's definitely proof of potential unethical behavior. I think that there's lack of professionalism here. I think these articles should be an embarrassment to the Washington Post and to the individuals who wrote them. I think that it shows tremendous amount of negligence, especially when it's repeated day after day, multiple articles in a single day, and nobody ever questions it. Nobody ever says, should we try to get a fuller view? Is there anything else being posted out there? How should we present it? What's a proper way? Hey, should we even keep focusing this attention on a child? What's going to be the harm? We don't have the full story. We're focusing our little articles on children. What's going to be the implication? How are people online going to respond to them? Are they likely to receive death threats? What kind of mail or calls their parents are going to receive? What's going to be impact on their school? Nobody gives it a thought. They're just running with the story to compete with the news cycle on Twitter. Lucifer never changes. Cool name. You mean the fully semi-automatic assault smirk? Part of what the complaint argues is that there's this constant repetition of the smirk that creates an impression of the child in a certain way. You know, sometimes you can say everything, but you choose the word that create impression that then lead to, well, this kid must have done something wrong. So even when the post did not actually say something like that, they use words and descriptors that creates that impression. Unfortunately, that often is not enough to be the basis for defamation. It really are statements of fact. And that's why I go back to saying they needed to really focus on specific facts, not so many, not say basically that everything is defamatory. Focus on specific facts, put them into a timeline. Jason Craig, will this lawsuit deter MAGA slander for big media? Absolutely not. No, because there's been many of these lawsuits in the past. The media often wins, but they've lost many times as well. We haven't seen that being a real deterrence here. I think that right now they're struggling for their lives. They don't know how to compete against Twitter, YouTube, Facebook, and so they are investing less in true investigative reporting and more in people that can just get the story out in a matter of minutes to really compete with the news cycle on Twitter. And until that changes and they find a place for, you know what, we're going to be a place for genuine news and analysis. We're going to be even-handed. We're going to make sure that we don't publish anything that target children or target people without actually getting the full story. Until they represent something, I think this is going to come up again and again. Shannon Azul. How much does the fact that the kids are just that, minors versus if they were adults, should be more protecting for them, should there not be? I think that not on the basis of defamation. I think that once you get to that point, I mean, I think that children have faced the same exact standards when it comes to defamation as adults. So, but once you get to the point of declaring them defamation, I think then you get into damages, and then you can bring in the fact that they are children and what kind of damage you've created, the fear that you put them under, what kind of harm there is for their future, you know, or for the community and for their parents and everything else. I think that comes in a little later. But the standards don't change because they're minors. 10-hour loop. Hey, loving your video. Sadly, the live stream is so late my time. I can't tune in that often. I know. About 6 months ago, I was doing it twice a week. So I was dividing it up between people in the US and people in Europe and Australia and more convenient time. It was just very, very difficult to maintain that kind of a schedule to always be prepared for the live stream. So I apologize. So that's just what fell down. I apologize. Nigel Rhodes. I think the thrust of the argument is that they did not do due diligence by ignoring facts from the live stream. I don't argue that they... Okay, so there is that. But to do that well, first of all, you would have to actually set up a timeline properly and then say that this was available. Not just that somebody uploaded it, but what's the likelihood of anybody specifically catching it or seeing it? You know, there's always evidence out there. Does not mean that you find that piece of evidence, but you've got to do more. So to do more to show that, for instance, let's say there was a live stream or a recorded video that showed the full set of events there. I don't know, an entire hour of actually what happened there. Can you then go online? It shouldn't be that difficult, right? If that exists, and show, you know what? How many people reported on it? How many people talked about the fact that there is the full video available? Did any large media company did it? You know, was this something that was widely known, or was this, you know, a small minority that knew about it, just didn't really explode out there? That's the kind of argument you have to develop to really get there. Now, again, you can do that by amending the complaint, but that's kind of like what's missing here. Really a timeline that shows how information spread across the internet and where these particular articles fit in. So we get a sense of, look, other media companies already knew this story, but the Post was still continuing to repeat this false narrative. They had to have known, or at least they were negligent in not knowing that these alternative facts were already made available on the internet. Jason Kai, my understanding, the false statement of fact. 1, children approached the man. True. He was a Vietnam veteran. The children were chanting "Build the Wall." Are those not in there? Okay, so a few things. The very fact that there's the very fact that there are statements that the kids approached and surrounded the elderly protester, that's false. Every instance I've seen it, it was repeated by other individuals, not directly by the Post. Now, I might be wrong. They may have said it themselves in their own voice, but when I was looking, what I saw is the voice of others, like Phillips. Maybe you could argue that he should be sued for defamation for having lied on national TV and put those kids in danger through his lies. That's another story here. But when the Post was repeating those quotes in the articles provided in the lawsuit, which is provided by Sandmann's attorneys, it seems that they are repeating what some other people are saying. That's why you need that timeline to show whether or not it was reasonable for them to repeat it or not. What's the likelihood of them understanding that that was not true? The fact that he was a Vietnam vet or not is probably not the kind of fact that leads to damage. And that's the problem here, right? It's a false statement of fact that when repeated damages somebody. So that's probably, I mean, you can argue that, but I would say that that in itself is not a cause of damage. It might have aggravated the situation because people say, oh, he's Native American, he's elderly, he's a Vietnam vet, look at this kid. But that'd be kind of a hard stretch to say that that false statement is actually one that leads to damages. And your third one is the chanting of Build the Wall. You can argue that that was indications of aggression. I mean, that was the impression that we're trying to create. Again, a stretch, but I agree. But that was another statement, as far as I can see from the articles provided by the plaintiff. It's when the Washington Post is repeating what somebody else said. And that's what it comes down to. If I say they were chanting, now it's my statement, and I can be held liable for defamation. But if I say you said they were chanting, as long as I'm not lying about what you said, you actually said it, well, I'm not going to be liable for defamation unless you hold me to a different standard, like negligence. And for that, you have to show the timeline. You have to show why I'm negligent in repeating your statements because I should have known better. Nope, help no. I thought rules were different for non-public figures. They are. Non-public figures, a non-public figure can sue for defamation based on negligence. It doesn't have to go based on showing that there was intent. There would be, in this lawsuit, they're saying that there were both. They are expecting for the Washington Post to say, well, no, the kid was a public figure. At least for this narrow scope, he put himself into the middle of the storyline. They're probably going to raise the fact that he was not identified until he identified himself. I forgot the publication, might be the National Enquirer, where he actually issued a statement and then he identified himself. That's the argument they're going to make. I would say that that's a false argument because they pushed him into the public arena. They focused their articles on the child. They kept describing him. They put him at the center of the story, and they kept repeating false allegations made about him. And as a result, they can't claim it. So I think there are different standards, but I think it's going to be based on negligence, which is a standard for non-public figures. Kasperian, have you heard about the Steven Crowder versus ABC case? I guess Crowder is suing ABC for issuing a copyright strike against him for live streaming their reaction to the Oscar. I heard the story. I didn't think that there was a lawsuit, but I will check on it. But I heard the story. I saw it like, why is this exactly happening? And so this will be a question of fair use, and not having seen the stream and what was said, it's hard obviously to comment on whether or not I think it's fair use or not. Needless to say, I think that companies are very quick to take down videos. I see it all the time. I have clients constantly dealing with this kind of nonsense of their videos, their pictures, all taken down because people are refusing to even consider fair use. So if he's in fact suing, that'll be an interesting one. I'd love to cover it, but I don't actually know. Sidoku. Do you believe censorship accomplished? That's what we just did. Nope, hell nope. Also, many refuse to make retraction, etc. I agree. I think that based on what's shown, I cannot speak about later articles. I have no idea if the Washington Post later issued a retraction. But now, well into a day where everybody knew that there was a fuller video, the Washington Post doesn't mention it till the very end of the articles. They keep repeating false allegation. Again, they're not repeating in their own voice, they're repeating in the voice of the individuals saying it. But at that point, I think you get them on negligence. If you showing that again, you have to show a timeline, show how everybody else, but by that point, they all know about it. And I think that by them putting the statement at the very end shows that they already knew that those statements they're repeating in the beginning are false, yet chose actually not to show contradictory statements until the very end. So I think in those later articles, there is sufficient proof of negligence here if it's just drafted a little better. JJ, there have been no retractions. Angela Richter, they have doctored the original video from which everything else flowed. Poison tree principle, and also they did not at any time use any journalistic standard to check their work. I think that it's clear that there were at least unethical standards work here. Completely shoddy. The very fact, I mean, it's supposed to be the Washington Post, that the correct English was not even used in their headlines here. That it seems that they're just all of these articles. There are 7 articles in the span of 3 days, and many times they're repeating each other's statements. Almost they're copied quote for quote, line from each other. There's really no even attempt at actual investigation. Just an attempt, in my opinion, to spam the news lines basically by dumping more and more articles so they can get better ranking on Twitter, Facebook, wherever it's being shared. I think that's where the heart of the problem is here. I think you've got people that care very little about journalistic investigation, integrity, ethics. I think they just want to get their story out there, because the more stories, the more headlines, the more likely that you'll be the one that's going to be, that your story is going to go viral. I think that's what they were chasing here, and I think that's where you get them, to show that in order to try to make sure that your article is more likely to go viral, they are repeating statement long after they know that it's false, because they can show it in the second to last paragraph that they knew that there was contradictory information available. What's going on here? Oh, yeah. First last. Thanks for covering this. It really helps. Hold on a second. Let me just go through here. First last. Thanks for covering this. It really helps clear up some of the question I had after reading the complaint. Thank you so much. Earthbound Kid 1. Doesn't this case fall under the Gertz versus Robert Welch, Inc.? I am not aware of that particular case, or at least I don't know that particular name. Sorry that I can't help you there. I'll have to check it out. Oh, miss you, baby. That's my wife. She's out of town. She writes it. Here. Oh. Some unicorn sprinkle. Someone is stealing your girl. Well, thank you. Georgia. You good are over. Okay. I think that's a lot of conversation with my wife there. That one guy who does that thing. What do you think this case is going to cost? Is one side going to run out of money before the other? I don't think so. I think that this case is going to be fought. These newspapers don't move towards settlement very quickly until they lose something here. So right now, there's no chance of settlement until you get past the motion to dismiss, until you start pulling together, start actually looking at internal documents. You're going to go through discovery, demand all the records to see exactly how the story developed, what the reporters knew, what the editorial board knew, all that information. At that point, there's a potential for settlement, depending on whether or not they're afraid of what the notes actually show. A lot of times they're not concerned. It goes forward. What do I think? This is probably $150,000 easily by the time it gets to a judgment. And I think that they will not run out of money before judgment, because if they did, they can raise it very easily on GoFundMe. So I don't think it'll be an issue here, but it's going to get expensive. It's a difficult case. Can you write an amicus brief outlining the timeline? I think that his attorneys need to do it. it would demand a lot of time, because you need to do a lot of research into what happened on the media, what happened on social media, when did different videos when different videos come online, and when was it reported, how many people actually saw it. You look at actual statistics through Twitter, for instance, and actually views on YouTube. So it's an enormous project, and right now I'm kind of busy with the project against Patreon, PayPal, and Stripe, so I can't do that. Theodore Stinson, what do you think about the 250 million? What do you think the reason for that number is? It's huge. That's what the number is. It's not tied to anything specific. At the end of the day, it's a massive enough number, so it can lead to a potential settlement down the line, and those settlements will be huge no matter what. If there is a settlement, you're probably looking in excess of $100 million settlement here. But for that to happen, you'd have to push the Washington Post past at least discovery. You'd have to get to a point where you're demanding information, interrogatories. You're actually asking people questions. You're actually getting discovery, look at some of the reporters' notes and editorial boards and all their records to that point. But I don't think there's any basis to it except the fact that they wanted a large number. That will be argued down the line, because ultimately that's what defamation is about. It's not only about showing actual injury, reputation, finance. That's not something typically that you can get from kids, because unlike adults, they're not really suffering an impact from not being able to get a job or getting fired or anything like that. So you're going to have to connect that probably with some damage to like emotional distress or something like that, and you'd have to justify it, and that's a number you can take in front of a jury. John Bushka, is it likely that a relatively non-celebrity blogger would get sued for a false statement about the facts of the encounter in a blog or post? Seems like they only went after the Washington Post. Well, a couple of things. You go after, first of all, where the money is. So no, I'm not going. If I'm his attorney, I'm not suing a random blogger, because there's no money there. If I think that if the individual had a wherewithal, or it's after an organization that has the money or backing or the investment in it, now it makes for a better lawsuit. You don't sue if you can't get anything back. It makes no sense. You're wasting your time, and you're not going to get anything out of it. At this point, the story is kind of spent, so it's not as if you're going to you want the storyline to end, so you want the court to stop them from saying certain things. So this is really about damages here. So you're going to go after the big company. Why the Washington Post versus everybody else? I really don't know myself. Jackson Kai, I believe the Washington Post may have broke the story and also took the longer to correct. Not actually sure if they are corrected. That is my guess why they were chosen. That could be the case here. It could be that they pushed harder than anybody else and they never really fixed. At least we didn't see it from the articles provided. Could be that at some point down the line they retracted it. By this point, again, to me, that was a good article provided by the plaintiff. The last two articles, which actually showed that that they're repeating false allegation, but then only fixing it at the very end of the article. So they knew that they are repeating information that is otherwise false, which will give you indication at least of negligence here. That they were negligent in the way they investigated, negligent in the way they wrote it, at very least. Seco 212, if a tree falls in a commie and there's no witnesses, who is the oppressed? That's the first time I heard that one. Your TV hates you. They went after the Washington Post because Bezos has money. Yeah, that's who you want to sue. You want to sue the people that have... Look, when did I ever... I told you before, I don't follow politics or social media, so I didn't know about it the first time I saw it, because it was, what, Saturday morning. I open up the computer and I see the little idiotic little handheld video by Philip DeFranco calling out the kid based on that clip without knowing the facts. At that point, I myself don't know the fact, but the first thought is, how can you as an adult speak about a child? Whatever else you think, do you have a sense of what's going to happen here? So yes, a lot of people were irresponsible here, but that in itself probably does not get you liability. Being irresponsible, not professional, not waiting for the full facts to come out, probably not get you sued for defamation. It's the repetition of information in the face of information that to the contrary. Because once information came out that this is false, individuals, bloggers, YouTubers, different media companies did issue retraction saying that this was wrong. This did not happen here with the Washington Post, at least not in a timely fashion here. Doug's mom. Thanks for streaming this. It's very informative. Thank you so much. I appreciate it. Douglas Moran. How important are precise meaning of words? The more salient was surrounded, which requires being on all sides, whereas the earlier video showed that the students were not behind Phillips. That's interesting. I would say that the technicality of the word is probably not going to get you there, because that's going to fall under just creative writing, you know, where he was surrounded. To me, when you say that the children surrounded the adult, it seems to me that that was an active part by the children. The children actively surround. It's a verb versus an actual descriptor of a moment in time, which would be okay whether or not they actually surrounded him or he walked into them, which resulted effectively of him being surrounded because he inserted himself. The problem with that is, you know, that's where you get into an argument with journalists and saying, no, I used a word, this is what it's meant. Yes, it could mean other things, but it has a broad meaning. You get into those arguments. So I don't think that's going to be the winning argument here. I definitely believe that they created an impression when they used the word surrounded that it was an active part by the children. And I think that's what it was meant to be. I think that in repeating that statement, they want to create an impression that the children acted in surrounding him. But I'm not sure if the court will see that a statement of fact, rather a statement of opinion describing what existed in a moment of time. Nope, help, nope. Brown shirts gotta take out red hats, all that matters to them. JC. Sorry, repeat what the previous journalist wrote and they just retweeted and copied it. Investing less. They didn't even investigate at all. It was just a circle the wagons and repeat was the previous journalist wrote. I agree. I think that it showed at best, it shows that there was no journalistic integrity, that maybe the skill was lacking, that these people didn't know how to write. They literally borrowed paragraphs from each other. They used sentences that each other wrote. They wanted to get out the article. I think that was the first thing. I think that that's a problem right now with journalism, is that and it's part of the way we consume news, that there is opinion and investigation versus news. So yes, we consume information very quickly. You know, it's showing up on Twitter, we're reading it, and the news media is trying to compete with that. And I think that's a losing battle for them. They cannot compete with everyday journalists, just literally every single individual with an opinion, with a statement of fact, whether or not what the way they see it. And I think that that's what they're battling, and that's why you're getting this kind of terrible article with no real fact-checking, no investigation into it, because they're competing. And I think that the only way for them to, not every paper, not every TV station and not every paper will succeed, but the one that will rise to the top will be ones that say that we are not competing based on time or breaking the story. We're going to compete based on investigation and being fair and actually revealing what's happening behind the story. Stegas. Crowder has stated that he plans on taking the fullest legal action that he can, but hasn't explicitly said there was a lawsuit yet. Exactly. I mean, there is a cause of action for filing a false DMCA. The problem with these is it's just very, very difficult. You might agree that it's fair use or not. The problem being that, and that's just a problem with the way the law is, fair use is simply very difficult. You can never, if somebody comes to me and asks me, is this fair use? I would say I can give you an opinion. I cannot tell you, because the law is not written that way. It leaves it up to each judge to make a decision on their own based on their own standards. They don't even have to follow the four questions that are built into every fair use. They're required to ask it, but they're not required to follow it in their decision. It makes for very difficult cases. So would I start a lawsuit? I would generally advise against those kind of things because it's so difficult. So unless you're trying to make a point and you have the money to back it up because you're trying to make a point, I would say you move on and you stream another one. Michael Crawford. Can the media side of the case also considering naming him as he was a minor? I don't have information on it from what I gleaned from the complaint, and it may not be a true statement of fact in terms of timeline. It seems from the reading that name-wise he outed himself. I may be reading it wrong, but that at least from the Washington Post side, I don't know other media, that they didn't name him until after he published a statement on his own. But I don't know how other media companies did it. The 3D video. What do you think about the Ice Poseidon drama where he claims to not be running a Ponzi scheme but describes the site like you would describe a Ponzi or pyramid scheme? That's an interesting story which I haven't heard. So I'm going to put it into my notes here and I'll take a look at it because I literally have no idea. That seems like an interesting storyline. Thank you. Nope, help, nope. We should start a movement to convince Washington Post to rename himself The Prophet upon a reference. I do know The Prophet. Unfortunately, I'm a geek and I watch way too many Harry Potter videos on YouTube. Maladjusted 1. Because of the similarity between all of the report, is there an offhanded way to go for a conspiracy claim too? Probably not. This is a clearly a defamation case. But again, you can, unlike a public figure here, that for whom it's difficult to win this case, this defamation is always difficult. But this is based on negligence. So I think if it's structured properly, you can show negligence here. Because you can show how information spread across the internet and when it would have been reasonable for a reporter that actually is involved, that's writing multiple stories, not just one story, and reporters that are copying other reporters' information, that at some point they should have actually done some basic investigation to see if what they are repeating is true or false. At what level do we expect reporters to live to a higher standard than somebody on Twitter or YouTube? Nope, help, nope. We should... Oh, no, I did that. Dax Jacobson. The kid could open up a legal fund and $5 million will flow in 30 days. I agree. This is not a case for which it will be difficult to raise money. That one guy who does that thing. Thank you for answering my question, and thank you again for the work on the complaint. Thank you so much. I appreciate it. Arshal Smith. Can Jeff Bezos be personally responsible if it's proven that he pushed the damaging narrative? No. He's going to be covered, because even if that happened, he's going to be covered as an officer director, the insurance policy, by the... You'd have to go more. You'd have to say that it wasn't just, you know, bad journalism, but there was some sort of vendetta here, that he was personally acting in his personal behalf, not in his position as an employee of the Washington Post. So it's highly unlikely, even if he gets sued, all the officers and directors are covered by insurance policies. So highly unlikely. Sarah Hussein. What if the journalist who wrote the articles got fired? Is the lawsuit still valid? Absolutely. The Washington Post is valid. The Washington Post is liable even if they fired the journalist. I think that whether or not they fire it, I think that if it gets past the motion to dismiss, and now you are delivering the demands for discoveries, interrogatories, and if they find that there's anything very damaging, they are likely to try to fire the individual as the step toward a settlement, to basically try to distance themselves from the journalist himself and say, well, it's not really us. He didn't do his job. You know, we'll make some fixes to the editorial board, but not much else. Becky, do you think these possible lawsuits against the celebrities have any merit? People say crazy things on Twitter all the time. They absolutely do say crazy things all the time, and that's why a lot of times they're not liable, because it's statements of fact. People say awful, awful things to people. They say to children, but they're not liable for it, because in the United States we respect free speech so much that we allow people to say terrible, terrible thing. Some people will be surprised to hear what I'm saying, because there's so much censorship online by private company, but as a society, legally, we have the highest respect for free speech, and that's why really we are at a level beyond any other country, except that all this being contradicted. Our problem is in the private sector. It's not in the public sector. Michelle C. Most of the YouTuber journalists did do due diligence and waited for information. I don't disagree. I think that not everybody jumped into this foray like Philip DeFranco did. I think that was a particularly egregious act. I was surprised. I think that we should all pause when we're dealing with children, because we know what's coming. That when we point to children and online and we say they're doing something bad, that we know what kind of damage can happen, how many people can attack them verbally and threatening them. So I think that people should take pause here. And I think we're done. We're a little over an hour into it. The stories are over. The questions are over. I really thank you very much. I hope that you enjoyed it. If you have any questions, any concerns, anything you want to discuss, you want to talk about it again, leave it down below. What's going to happen here is that this video is going to be archived the minute we stop it. It's not going to be available on this channel. It's going to be re-uploaded to the secondary channel called Legal Dissent. So if you want to see the whole thing, go to Legal Dissent. I'll probably upload here a snippet of that video. Probably the beginning part of it should be uploaded tomorrow. As always, if you have questions and concern, put them down below. I'd love to talk to you. I'll see you next time.